So those of you who've been with us the past few years know that at WeLu, we do not wade gently into the waters. No, we dive straight into the deepest part of the deep end. And we do that through the session that we're about to kick off right now. And this is our litigation panel. And in this, we bring together some of the top attorneys and subject matter experts there are. This features our legal committee, past and present, employers group legal committee. For any of you that is not familiar with that legal committee, this is a group of really the top that there is, and they work on behalf of employers everywhere, and they work diligently to represent your needs and your issues, and work on your behalf to make things a little bit better for employers. So I'm really honored to have some of them here today. Bob Rogenson, Warren Jackson, and Jonathan Turner. This is really an important part of what we do in order to get things kicked off. So I'm going to turn it over now to Warren Jackson, and we'll get our panel started. So thank you, everybody, and welcome to WeLu.
Thank you, Bill, and good morning, everyone. I see we're at 114 participants and counting. So thank you for those who got up early to join us. As Bill mentioned, I'm joined by colleagues I've known for decades now. Barbara Jensen, who's at the Ogletree Deacons firm here in Los Angeles, and Jonathan Turner and Mitchell Silverberg and Nutt, also here in Los Angeles. I am a neutral at Signature Resolution, but formerly in-house counsel at DirecTV. So we'll be quick and dirty with respect to our introductions. Let me just say this, that you're about to be wowed. I've got two people who are experts in their field, and so we're going to cover. We've got three main topics. Bob is going to start us off with a summary of some issues and cases before the California Supreme Court, with a principal focus in the wage and hour space. Jonathan will talk a little bit about some recent developments involving the National Labor Relations Act and the NLRB that are timely and important to employers, big and small. And I'll follow up with something straight from the headlines with respect to diversity, equity, and inclusion programs and the impact of the recent Supreme Court case striking down race-based university admissions programs on what private employers are doing. So with that said, let's get started. Also, I believe there's a paper that was prepared for another panel that covers some wage and hour issues that's part of this program. At least I thought there was last time. So, Bill, you're muted.
I should be unmuted now, right?
No, you're unmuted now. Yes.
Okay, great. That should be included in the package that everybody received this morning. So under presentation materials, if you click on that. Thank you for mentioning.
We're not going to follow. You guys should review it later. We're not going to follow that. We're going to be as Bill and Mark, you say we're going to be drinking from a fire hose, so we're going to be going pretty quickly, but we've got a little bit less than an hour to rock and roll. So with that, I'll hand it over to Bob, who's going to talk to us about what the Supremes are about to do.
Thank you, Warren, and good morning, everybody. Today, I'm going to talk about some significant cases that are pending before the California Supreme Court. And right now, there are 12 existing cases before the California Supreme Court. And as many of you are well aware, the California Supreme Court, which is the top court in California, has over the last 10 or 15 years issued some very significant decisions. In many cases, not all cases, but in many cases, they were in decisions that were adverse to employers, that reversed or changed the direction of longstanding California law. Where we stand right now is we have many new members to the California Supreme Court. We also have a new Chief Justice, and it remains to be seen how this, I think, newly configured court is going to treat some of these significant labor and employment issues. There's 4 issues that I'm going to address today. The first is going to be on Private Attorney General Act case, or PAGA. The second will be focused on rounding and timekeeping practices. The third is going to focus on hours worked, what constitutes hours worked, which is, I think, the base of all wage and hour law. And then the fourth is arbitration. So let me start at the top with PAGA. And as many of you are aware, Private Attorney General Act claims are now commonplace and filed against employers of all types, big and small, companies that have robust, vigorous compliance steps, as well as those that have been reckless or non-compliant, or all are subject to these PAGA claims. And in a recent case that went to oral argument last month, the case is called Estrada versus Royalty Carpet Mills. The issue in this case is concerns what abilities does a trial court have to limit the manageability of these cases. Let me speak to that in real terms. What we are commonly seeing are plaintiffs filing a PAGA claim on behalf of all of the workers for that employer, and there may be a myriad of claims alleged: meal periods, rest periods, overtime, minimum wage, reimbursement, itemized wage statements, waiting time penalties, a whole variety of different claims, and alleging on behalf of all types of workers. And the under the PAGA statute, that one worker is able to maintain the claim on behalf of all of the workers for that employer, whether they work in the same space, same location, same capacity. And what this presents at the court level for us lawyers and for those employers that we represent is, how in the world does trial court manage this type of case? If it does not settle and it does head to trial, how in the world can a case like this be tried? And the issue in Estrada is whether the court has the ability to limit or strike certain PAGA claims based upon the court's conclusion that to allow that to proceed to trial would be unmanageable in such a way that it would deprive the employer of its ability to defend itself under constitutional due process rights. There right now is 2 competing Court of Appeal decisions. One involves Estrada, or is the Estrada case, in which the underlying court concluded that no, the trial court does not have the right to strike PAGA claims. That decision conflicts with an earlier decision in a case called Wesson, W-E-S-S-O-N, where the court concluded that a trial court did have the right to strike or limit certain claims based upon manageability. At the oral argument that took place last month, there was quite a bit of skepticism of the employer's point of view. A number of the justices seemed inclined to rule that the court could not limit and strike PAGA claims. Fortunately, there were a few justices that were weighing in with some expectation and belief that that although it's a rare remedy for a trial court to strike claims, that the trial court did have the ability to strike claims. We now need to wait the decision. A decision is expected by February of 2024, hopefully earlier. I think having viewed the oral argument myself, I am somewhat hopeful that the court does put some limits and will put some limits on trial courts, or allow trial courts to put limits on the parties on bringing the claims, but we'll have to wait and see. I think it'll be a real bellwether case in my view as to what this current court does. One challenge I think we've had is that the court has seemed to lack a real understanding of the practicalities of what employers face day to day, and also what courts face day to day. And hopefully we're going to see a more realistic ruling from the Supreme Court in this case.
Bob, let me ask you a question before you move on.
Sure.
given that from my perspective as a neutral, most of these cases, PAGA or class cases, settle before the class certification stage, fairly early on after some limited discovery. Do you think, no matter which way the Supreme Court goes on this, will it have a practical effect in that context, in terms of, one, whether the ease of or the practicalities of getting these cases resolved via settlement?
That's a great question, Warren. And I do think the court's ruling will have an impact on the settlement posture of cases. With arbitration, which I'm going to talk a little bit later about, impacting and really impacting favorably for employers' class actions, the activity has moved over to PAGA. Well, in the typical case, a lot of trial courts will just defer making the hard decisions on manageability. And with this uncertainty of whether a court had the ability to make manageability, it put a lot of pressure on employers in mediation. And I think it also helped plaintiffs and worker advocates leverage high settlement demands and often high settlements because the employer faced this real risk of having to try a PAGA claim. Well, if the court rules in the employer's favor in Estrada and does give the discretion to the court to strike or limit PAGA claims, then the shift is going to turn to what the court does and how it evaluates that. But I suspect employers will argue in court now that the court should make an earlier determination of manageability, or at least an earlier determination or some type of earlier showing by plaintiffs that they're going to be able to try the case. And I think that's going to immediately translate in mediations to more leverage for companies to get better settlements. Conversely, if the court rules in favor of workers and says that the trial courts don't have the ability to limit PAGA claims, no matter how unmanageable the case may be, I think that's going to significantly increase the leverage that workers and plaintiff attorneys have in mediation. I suspect that's how you probably see it too, Warren, right?
Yes, thank you.
Yeah, and highlighting that point, because of this, and I think because of trial courts' unwillingness to make some of these hard decisions and likelihood that they will, it's going to continue to be really important that parties and employers engage good mediators, figure out a way to get that case resolved, identify the arguments, because that may be really the only practical off-ramp for high stakes litigation in which there is some real exposure the employer might have.
Bob, I got two generalized questions related to this. One is, I know PAGA was enacted in 2004, and the whole idea behind it was, the Labor Commissioner's office was understaffed, didn't have the resources, so they created this inventive way for people to act as private attorney generals. Are the cases, when they're looking at this whole question of manageability, I'm just curious, did the Labor Commissioner, before PAGA was enacted, bring these kinds of cases where you've got multiple employees that are affected in the case? And if so, how did the courts address the manageability issues at that time? And then secondly, another unrelated, but I know that 2802 of the Labor Code talks about reimbursement of items that are not, as far as I know, characterized as wages. Just for the benefit of myself, who's not familiar with this world, and maybe others out there as well, the fact that those are non-wage items, they would still be covered under a PAGA action if someone wanted to bring those kinds of allegations? Those
are two great questions. The first question, I think that's the most important question, is what the PAGA allowed a private plaintiff to bring the same exact type of lawsuit for civil penalties that the Labor Commissioner has always been able to bring. And as some of you may know, I used to be the chief counsel of the Labor Commissioner and was in the position where we did bring claims, civil actions against employers on behalf of all the workers, and we would seek recovery of wages as well as civil penalties. And the one thing that I recall from that time was our concern as the Labor Commissioner: how in the world were we going to be able to try this case? Because we would have evidence that was based upon maybe a small part of the workforce and other evidence, but we did not have evidence about everybody that worked for the employer. We would typically have just a partial evidence. And it was very difficult for us to bring lawsuits and develop the evidence to take all the way through trial. I am surprised and shocked that the Supreme Court is not really looking at that specific history here, because the California Supreme Court the Labor Commissioner has all but abandoned filing civil actions of this type and now go to citations for that exact reason, that they cannot maintain this. So the short answer is that the Labor Commissioner couldn't bring these because, or it was very challenging, I should say, for the Labor Commissioner to bring these. And now the court seems to be giving that history short shrift and saying, well, a plaintiff should be able to have these greater rights now than what the Labor Commissioner has historically had. And that's a really troubling, I think, development. On the 2802 question, I think you certainly can bring a PAGA claim for 2802 or the civil penalties for violation of 2802 to be more precise. And I think it is harder for a court to determine whether specific individuals in a PAGA class have actually suffered violations of 2802. So I think it is going to be much more difficult for a court to determine how a case can be tried, where there may need to be these individual determinations whether a worker was fully and properly reimbursed for expenses.
Yeah.
So we'll see.
We got to go. You got about 10 minutes.
All right. I'm going to go through my remaining cases pretty quickly. The next case is Camp versus Home Depot, and this is a rounding case. And I think this is probably the most significant case I'm discussing today, because this follows a Court of Appeal decision, underlying court decision, in which the court concluded that Home Depot, because it had a timekeeping policy or a timekeeping policy that tracked to the individual minute, was not entitled to round. Now, rounding, as you all know, is longstanding. It's longstanding allowed under both federal law and state law. But this is an issue now where the technology has timekeeping processes which can capture up to the full minute. It is expected the California Supreme Court has not yet ruled. The briefing, I believe, is complete, but not yet. Oral argument has not been set. I think there is a great anticipation for the case and an expectation the California Supreme Court is going to uphold that unfavorable earlier lower court determination that where the employer has a timekeeping practice where tracking to the exact minute, so some type of electronic timekeeping mechanism, that the employer is not entitled to round. Now, that may not extend to other types of employers where time is kept by the worker or by a supervisor through written handsheets or written timesheets, which are still allowed. And in that case, it may not be capable of prohibiting rounding because the timesheets themselves may already include rounding. One thing that I'm concerned about is the California Supreme Court, in many of its decisions, issues a ruling that changes the long-standing standard and then does so in a retroactive way. So I think the big takeaway on rounding is if you have a policy or a timekeeping practice that allows you to capture time to the exact minute and second, that you do not round. Because if the court comes out unfavorable on this and makes it retroactive, that will create some significant exposure for those companies that have up to this point rounded. Let me turn to my third case. The third case is the hours worked case. This is a case called Huerta versus CSI Contractors. And this case is a very interesting case on whether commute time constitutes hours worked. And the facts in this case involved a very, very large construction site in which the workers had to go through a security gate, and they were on property that was now controlled by the contractor, and they had to drive some 30 minutes to the actual work site where they would park and begin their workday. And the employer started the workday once the employees reached the actual work site. But the workers in this case alleged that because they had to go through a security gate controlled by the employer and abide by rules on the road, such as not stopping the vehicle, they were subject to discipline if they were speeding and up to termination for speeding or other reckless activity, that type of employer control was sufficient to convert that commute time to hours worked. Now, while this may seem isolated to just these large construction sites, in California, we have many sites that are large. For example, refineries, plants, big distribution centers, movie studios, amusement parks, all of these different types of sites, including large buildings where the employer may control sites, but the worker needs to move to a certain location within the site before they begin the work. This case is fully briefed. It's not yet set for oral argument. I do think that the better side of the argument here is that so long as the employer is not exercising unreasonable control over that time the worker is spent going to the work site, that there's a very strong argument that this activity constitutes commute time. It is not compensable hours worked. But we need to wait and see what the court does with this case. I think the big takeaway is that there is this risk that the court issues an unfavorable ruling and finds all this commute time subject to the hours work definitions. So what I think employers need to do is look at their practices. If they have large facilities, what type of control is exercised over those workers before they reach their spot where they begin their work day? And are there bad facts there of control that could lead a court to conclude that time is compensable time?
Now, Bob, the same analysis I assume would apply to security checks and the people are lined up to punch the time card, time clocking, or logging into their computer in terms of whether that's hours worked, same or similar analysis?
It is. The bag check or security check cases where the workers have to bag check before they leave the premises. Well, in that case, and the courts have already ruled, California, well, that constitutes control, and that is subject to our. However, I think to the extent the employers are exercising the same type of control that they may be exercising in a bag check, it's going to lead to a determination that time constitutes hours worked. So we'll see. My last area, we'll briefly touch on this, is arbitration. I think arbitration agreements with the class action waiver remain the single best defense an employer has against a class action. As you know, or should know, it not apply to PAGA claims. There are 4 in front of the California Supreme Court this time. So,
Bob, you're dropping. You've got a low bandwidth, so we're losing you, sort of like every other word. Oops.
We'll see if that helps.
All right.
Well, let me just briefly sum on arbitration. There is United States Supreme Court in Bissonnette versus LePage Bakeries. And there's a significant issue in Bissonnette. There's a battle between California and the United States Supreme Court on the viability of arbitration in the employer space. And must rely upon the Fair Arbitration Act, Federal Arbitration Act, to enforce their arbitration agreements. There is a significant carve out under the Federal Arbitration Act for quote unquote contracts of employment with transportation workers. And so far that exception has been limited to transportation workers in the issue before the court in this Bissonnette case is whether that restriction of to the transportation industry, airlines and trucking companies, is, and there is a concern that the court may say, no, we're just going to look at the worker and whether the worker is engaged in any type of interstate commerce. So this may apply to a distribution center worker where they are handling goods that are coming in from out of state and then being distributed to stores or consumers. And the worker in the distribution center, for instance, doesn't do any traveling interstate, but is handling goods. So this is a real significant decision. If it goes in favor of employees and against employers, it's going to broaden this exception to the Federal Arbitration Act and make it much harder to have an enforceable arbitration agreement. So with that, Warren, I'll turn it back over to you.
Okay, let's hand the baton over to Jonathan. You ready?
I am.
All right. We'll take about it's 8:36, so you've got about let's say somewhere around to 9 o'clock.
All right. I'll
Or
crash through.
8:55 maybe. All right, let's go.
All right. So there's a lot to cover, like in Bob's matter, and I'm sure in Warren's matter as well.
Don't worry about me. I'll clean it up.
I'm going to be covering the National Labor Relations Act and developments that occurred over the past year with the agency, the National Labor Relations Board, which is basically the agency that protects the rights of workers to form and join unions and engage in other protected concerted activities. The theme you're going to find here in my presentation is how the NLRB has pretty much over the past couple of decades now, ping-ponged back and forth and changing the law depending on who's in charge politically from one administration to the next. Because the political party in control, at least the president, elects or appoints for approval by the Senate, successor members of the board. Each board member, I forget how many years their terms are, but when their terms come up, the president can choose the next candidate. And in fact, that's also true with the general counsel for the board. The general counsel is the chief prosecuting office attorney for the agency, who decides what kinds of cases to proceed under the act. And we saw in the last, when President Biden was inaugurated back in January of, 2021, I guess, the very first executive action he took was to fire the board's then existing general counsel, who is Peter Robb, who was a management side oriented attorney before coming to the board. And he was fired even before his term expired. And there was some litigation that went back and forth on that. But ultimately, the court sustained Biden's right to take that action. Ultimately, Rob was replaced by Jennifer Abruzzo. That's the current general counsel for the board. She is a staunch supporter of organized labor, and I'm not making a judgment there. She would freely and unapologetically admit to that. And we've seen that through her memos that she's issued to the field offices and the kind of cases she's now trying before the NLRB. And one of the developments I want to talk about, and these are not all in order of time sequence, but just my own sense of importance, I guess. There's a case called CEMEX Construction, which was decided on August 25 of this year. And the general counsel issued a field memo shortly after that decision to clarify to the field offices how they should be interpreting and applying and enforcing that decision. It sets out new standards for union demands for recognition. And to understand that better, just some basic background. Unions have to be able, in the private sector, have to be able to establish majority status. That is to say that you got to define appropriate unit of employees who desire union representation. And if the union establishes that at least 51% of that group want them to represent them. By law, by federal law, the employer has to recognize them. How is that majority status determined? Well, generally, and the preferred method is through an election that occurs right there at the employer's place of business. The NLRB will actually send out a board agent who sets up these booths, and people come in and cast their vote privately in the same way you do with general elections. And then oftentimes right after the voting is over, right then and there at the workplace, the board agent will count the ballots in front of all the parties. And again, if the union has at least 51%, they then become the certified bargaining representative, which by law the employer has to recognize. There are other ways to determine majority status. There's something called a card check. Unions often will go to the employer and say, hey, you know, we've got a group of people, they want us to represent them. We can show you we have majority status. We'll produce the union authorization cards. You look at them, and if you decide, or if you agree that, you know, we have majority status, then let's sit down and bargain. That's another proper way to do this. But the employer, at least prior to CEMEX, didn't have to go that route. The employer could sit back and just say, thank you very much, but I think you should just go ahead and go forward with an election. How does an election actually start? It starts by filing an election petition with the NLRB. And the NLRB's, the union's petition would, it's called an RC petition. It starts at that process, but the employer also has an option to file its own petition. It's called an RM petition, but in both instances, you're asking the NLRB to conduct an election. Why would the employer want an election to go forward as opposed to doing this card check process? The general reason, at least how and why I would advise employers to go the election route, it historically has bought you time, because it gives you, you know, it takes about 30 to 45 days, sometimes more, especially under today's understaffed regional offices, to get from the point where a petition is filed and where an election actually happens. So what happens during the interim time is the employer can then reach out to its employees, as it has a constitutional right to do, express its opinions, as long as it's not accompanied by threats or bribes or any kind of coercion or intimidation, but to let the employees know their own views about unionization and why they don't think it's in the best interest of either the company or the employees. And oftentimes it's a way of messaging to employees to say, look, you've been told one set of information by the union. We think you should have more complete information so that when you go in and decide whether you want the union to represent you or not, you're fully informed. And that's why we want the election to happen, so you get a chance to hear our side of it. Well, CEMEX has changed all of that. They changed the playing field in a way that increases the likelihood that the employer is going to be required to recognize and bargain with the union. And here's how that happened. The CEMEX ruling basically says this: if the union demands recognition without having filed their RC petition, and the employer neither recognizes the union on demand nor files its own RM petition within 2 weeks of the union's demand, then the union can file an unfair labor practice charge, alleging that the employer has unlawfully refused to recognize and bargain with them. And the employer will be permitted to defend against that charge. The board will conduct an investigation. And if the employer is unable to produce evidence, or if whatever evidence it produces is not sufficient in the board's view to show that it could show the union did not have majority status, the board issues an unfair labor practice complaint. It will go to trial before an administrative law judge, and the employer gets another chance to try to defend against it by trying to show the union did not have majority status at any time. But if it's wrong, a bargaining order will issue, and that bargaining order becomes retroactive back to the point in time when the union made its initial demand. Now, the legal consequence of that is if the employer made any changes affecting wages, hours, or other terms and conditions of employment during that time, those changes would have to be reversed. If you changed, for example, some scheduling issues and you went through a lot of trouble to roll it out, that all has to get unraveled. You got to go back and bargain with the union over it. So as the general counsel said in its memo, employers act at their own peril in refusing to recognize and bargain, and in making unilateral changes in employees' terms and conditions of employment after such a demand is made. She's made
Jonathan, I don't want people to think the sky is falling. Isn't the answer you just file it, employer just files an RM petition, and that's not historically what they've done, but you get an election. Wouldn't you just do that? I mean,
you're going to have to do that basically. That is the whole point of advising employers about how to deal with CEMEX. You no longer have the option to force the union to file their own petition. You got to go off and file yours. And of course, you still have the same problem with the board's view of moving everything on a fast track. The elections move more quickly today because of changes in procedure where they are now saying, where the board is now saying, okay, you have a statutory right if you file a petition to go to a hearing, but we want you to know you're going to have to show us up front if you believe there's a legitimate issue to be litigated at the pre-election hearing. In other words, if you have some question as to the appropriateness of the unit or whether or not the union is a proper labor organization, all these kinds of issues are going to have to be told up front. And if you don't have the evidence to support that view, then this hearing is going to be very short. And so to your point, yes, that's the answer, is that if you want to buy some time, then what you really need to do after CEMEX is the employer should file an RM petition. You're still going to be faced with some real time restraints because of the pressure that they put on these election proceedings now. So let me go to another development that relates to this. The General Counsel has also issued a field memo. This is back in April of 2022, actually, telling its field offices that for employers who want to conduct a messaging campaign during the time before an election, and they want to express their views about unionization, historically, this has been accomplished through company meetings at which all affected employees are required to attend. It could be mandatory. And as long as the employer is not saying anything that's intimidating, coercive, threatening, or bribing, then they had every right to make their position known at these mandatory meetings. Well, the General Counsel's view is, you know what, it doesn't matter what you said or didn't say in that meeting that might be considered non-threatening or non-intimidating. We think that any kind of meeting like that, where you require your employees to come to listen to you, is inherently coercive. And so we're gonna, despite the fact that that rule has been in place, I don't know, since 1948, the General Counsel has said, we think the board has incorrectly adopted that precedent. We think it needs to be changed. So at the first opportunity, she is going to bring a case before the board asking them to reconsider and reverse that rule. Well, her memo was challenged in the federal district court in at least 2 instances, I think one in Michigan and one in Texas, but in both cases, the court determined they didn't have jurisdiction to tell her what kind of field memo she can issue or because she has the prosecutorial discretion to do what she wants to do on these issues. To date, I'm aware of one case that was presented to the board, and it was very recent, actually, I think November 28th, where the General Counsel advanced the position that, there was a captive audience speech given, and the board should have found an unfair labor practice. That case, the board dismissed, not because they were rejecting the General Counsel's position on. In fact, they made a point of saying we expressed no position about that. It was rejected because they adopted the administrative law judge's finding that their main witness in that case was not very credible regarding what occurred at these meetings. So the next development I want to talk about is union messaging on company uniforms or on or in circumstances that conflict with the company's dress code. There's a case called Tesla that was decided in 2022. And it has since been reversed again recently by a court of appeals in November 14th of this year. So in 2022, the board's decision involving Tesla, you had employees who work on the assembly line making these cars, right? And they all had to wear specifically designated uniform. Yeah, I guess you could call them uniforms. They had to wear certain colors of pants and shirts, depending on what part of the assembly line they were working in. And also, this was done so that management could visualize quickly to see that everybody was where they were supposed to be when they're doing their work. And also to minimize damage to the product itself, they had to wear certain types of articles of clothing. Notably, the company permitted employees to wear union buttons if they so chose and display other union insignia freely on their clothing, subject to certain restraints. But even so, the board determined that if an employee wants to come in and wear a union T-shirt instead of the shirt that you're requiring them to wear, then for you to tell them they can't do that, even if it's, quote, in violation of your uniform policy, that's unlawful. Their rule that they fashioned was when an employer interferes in any way with its employees' right to display union insignia, then the employer must provide, quote, special circumstances that justify the interference. And this rule applies whether you're looking at dress codes generally or whether you're looking at employer uniform requirements. The employer's burden under that rule is not an easy one to meet, and the board freely acknowledged that. They stated that consistent with longstanding board and court precedent, our decision reaffirms employers can maintain facially neutral, non-discriminatory dress codes and uniform policies that implicitly limit or restrict the display of union insignia, so long as they are, quote, narrowly tailored to serve a particular legitimate interest that outweighs the adverse effect on employees. Well, thankfully, from the management lawyer's perspective, the Fifth Circuit overruled this decision on November 14th of this year. And they expressed a complete rejection of how the board purported to, quote, balance the employees' rights under the Act versus the company's right to enforce non-discriminatory policies or dress codes. And the court chastised the board for adopting a standard that essentially made all company dress codes presumptively unlawful, because that was the effect of the rule, absent special circumstances. And the court also went so far as to hold that the board's decision on where to draw that proper balance exceeded, in that case, in the Tesla case, the board exceeded its statutory authority. And I'll quote from the court's decision. It says, finally, though we base our ruling primarily on the lack of balance that was shown by the board's new rule, we also note the board has exceeded its statutory authority in crafting the rule. This extremely broad rule would make all company uniforms presumptively unlawful, whether for white-collar workers or blue-collar workers, and Congress likely would not have intended to permit such a major decision without clear statutory indication. And for these reasons, it's well beyond the scope of the NLRA for the board to declare all uniforms and dress codes presumptively unlawful and thus subject to this special circumstances test. Well, it's a good decision for management. The board has to follow it in that case, but they don't have to adopt that rule in other cases, and I don't think they will. I think they're just going to continue with the position that they did in Tesla in other cases that come before it. Next area I want to talk about in terms of developments, the board tightened their standards for assessing generally workplace rules and policies, and this impacts not just union workers now, it impacts non-union workplaces as well. In a case called Stericycle, which was decided on August 2 of this year. And to understand that one, we need to, I was telling you about how the rules seem to change and ping pong back and forth depending on the administration, right? Well, during the Trump era, the board issued a case called Boeing, where they formulated 3 categories of work rules. Category 1 were rules that were always deemed to be lawful because the impact on the employees' rights was slight and the business justification for the rule was substantial. Category 3, I'm going to to the other extreme were those that were deemed always to be unlawful because they're just inherently destructive of Section 7 rights, and no business justification would immunize it. And then the category 2 is everything in between, where the board would then just do an individualized scrutiny of the case to see what's your reason for the rule, and historically, what have you done in the past, and how does it really impact on the employees who reasonably would construe it in one way that would chill their willingness to engage in protected activity if under fear of discipline, et cetera. So with category 1, the kind of rule that fell in category 1, at least in the Boeing case, they were a defense contractor, and they had highly proprietary and secret, Department of Defense products. So when you came into these work areas, employees were not permitted to bring their cell phones, concerned about taking pictures. So that fell in category 1. Category 3, on the other hand, is if you had a rule that says employees can't, under any circumstances, discuss their wages with other people. There's just no rational justification that would outweigh the employee's right to be able to do that. So that would fall under the other. And like I said, everything in between was very fact intensive and spurred a lot of litigation. Well, Stericycle abolished this approach for a more employee-friendly rule. They now
Jonathan, 2 minutes.
I'll finish in 2 minutes. Board examines whether a workplace rule has a reasonable tendency to interfere with Section 7 rights, and if so, the employer has to show a legitimate and substantial business interest for the rule, and that this interest can't be advanced with a more, quote, narrowly tailored rule. So you notice that narrowly tailored, they like that word, and they use it in ways that basically tell the employer, you're going to lose. NLRB test for independent contractors is something else that developed this year in a case called Atlanta Opera, decided June 13th of 2023. The independent, as you probably know, independent contractors are not protected under the Act. But how do you decide who is an employee and who's an independent contractor has always been fact-intensive analysis where you look at multiple factors to decide whether the hiring party had control over the manner and means and not just the end result of the work that they're asking for. Well, in Atlanta Opera House, the board reversed a Trump era decision in which emphasis was put on whether the workers had some entrepreneurial opportunity for profit or loss. Well, the board said, we think that's putting too much animated emphasis and importance on the task. So we are going to just say, you got to look at the totality of circumstances, which basically means it's more likely people are going to be found to be employees today. Then lastly, well, 2 more things.
Jonathan, you're out of time.
Okay. I've got material available for anybody else who wants to get any more information on this. So I'll leave it to Bill to let me know if anyone is looking for that or has any more questions on that.
Okay, we're closing at 10 after, right, Bill? I'm assuming we got another panel coming up. All right, let's switch quickly to DEI. June 29th of this year, the Supreme Court issued a long anticipated decision on the use of race as a factor in college admissions in 2 cases brought by a group called the Students for Fair Admissions, attacking Harvard and the University of North Carolina at Chapel Hill's admission policies as violating both Title VII and Title VI, I'm sorry, the Civil Rights Act of 1964, and with respect to UNC, the Equal Protection Clause of the 14th Amendment. Ultimately, the court effectively barred universities from using race as a factor. The case was brought on behalf of Asian American applicants. The lower courts in the First Circuit with respect to Harvard had upheld the Harvard admissions policies. Supreme Court reversed, although overruling a case called Grutter versus Bollinger, which had validated affirmative action in college admissions years before, provided the use of race was narrowly tailored to the compelling interest of promoting a diverse student body, and that there was a holistic process. Those of you who are parents and who have kids who've been applying to college and know that word holistic, that means murky, to evaluate each applicant as opposed to a quota system. Justice Roberts held that affirmative action in college admissions is unconstitutional, noting that many universities, quote, have concluded wrongly that the touchstone of an individual's identity is not challenges bested or skills built or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice. Now, significantly, nothing in the Supreme Court case actually changed the legal analysis for what private employers do in terms of determining whether an employer's actions violate the anti-discrimination law. And there are two cases that came out in 1979, Weber and Johnson. They weren't overruled. Those cases had allowed for affirmative action under certain circumstances in private and public workplaces. However, the makeup of the court has changed and the political landscape has changed. Now, why are we talking about this? Because that case has created a climate for attacks against DEI programs. And DEI programs have become sort of in vogue over probably the last decade or so, if not more, where companies have examined and assessed their recruitment, hiring, and promotion policies in an effort to eradicate bias, create and retain an inclusive workforce, and achieve what's something called equity in their personnel actions. Now, even those programs haven't been universally accepted, but until the Harvard case, most of that angst was sort of below the surface line, or at least didn't result in litigation. But that's changed. That same group that backed the Asian students in the Harvard and North UNC cases, led by a conservative activist called Edward Blum, have now sued and gone after a number of companies, including American Express, Starbucks, Amazon, Disney, and Facebook, alleging that their DEI policies violate either Section 1981 of the Civil Rights Act of 1866, Title VII, or state laws. And there have been, and in fact, even recently, I think earlier this week, I saw that a lawsuit was brought, or a challenge has been brought against the California aid program for Black and Pacific Islander pregnant women, challenging that the program provided aid to those specific ethnic groups and not generally across the board, and therefore that violated the anti-discrimination laws. So what happened post the Harvard case? On July 13th of this year, immediately thereafter, Republican AGs from 13 states, primarily the Confederate States, issued warnings to Fortune 100 companies, threatening serious legal consequences for their diversity initiatives. Basically, the AGs called those initiatives quotas, explicitly race-based practices, and warned CEOs to refrain, to cease and desist, essentially. In response, Democratic AGs issued their own letters disagreeing with that characterization. And so you had this stalemate in the political sphere. So what's happened on the legal front is that reverse discrimination cases alleging discrimination have increased. So basically, they include cases challenging harassment on the basis of having to attend DEI training, challenging minority vendor initiatives, corporate and government initiatives to diversify corporate boards, shareholder derivative actions targeting companies, DEI initiatives. There was a case out of Dallas where that was unrelated to sort of the reverse discrimination issue, but in a concurring opinion, Judge Ho listed a variety of possible affirmative action practices he believed would violate Title VII, including allocating professional opportunities for work assignments based on sex or race under the guise of furthering DEI, providing race-restricted access to mentoring, sponsorship, or training programs, selecting interviews partially due to diverse candidate slate policies, tying executive or employee compensation to the company achieving certain demographic targets. That's something that was really in vogue even going back to the 90s, where there might be a component of your bonus program on achieving diversity metrics. Basically offering race-restricted diversity internship programs or scholarships, or as I just mentioned, this aid program. We've also seen that law firms have been in the crosshairs. And so what's happened as law firms have been attacked, and and they basically began looking at their criteria and trying to sort of avoid litigation by removing the references to minorities or underrepresented groups in a way to sort of mute those challenges. And let me give you some examples of how that's worked. For example, Pfizer, Gibson Dunn, Morrison Foerster. Pfizer is a company, but let me go to Gibson Dunn. Gibson Dunn had offered scholarships to students who identify with an underrepresented group in the legal profession and who have demonstrated resilience and excellence on their path toward a career in law. They changed the criteria to just say Gibson Dunn offers scholarships to students who have demonstrated resilience and excellence on their path toward a career in law. Morrison and Foerster had a fellowship that basically recognized and supported the career advancement of highly motivated first-year law students who are members of historically underrepresented groups in the legal industry. How they modify it? Basically, the program has recognized and provided exceptional first and second-year law students with a demonstrated commitment to diversity and inclusion in the legal profession with the training, mentorship, and exposure for development. So basically what they're doing is, and some of this may be form over substance, I'm not sure. In that sense, I think they are legitimate efforts to try to thread the needle in terms of how do you, if we're committed to these kinds of programs, if we're committed to inclusive workforces, how do we get there and avoid legal challenges, which is not really the business law firms are in terms, they're in the business of representing litigants, not being a litigant. So, I mean, I'm not going to give any fearless predictions of what's going to happen, but, you know, what really non-marginalized groups, I guess I say, i.e. white men, have basically, these challenges are being brought on their behalf. I mean, we think, and the argument being, we think we need to level the playing field. So an employment law professor at Berkeley has asserted a way to do this while still promoting diversity would be to phrase criteria to instead offer opportunities to first-generation college graduates, those who have an interest in diversity issues, or people who have overcome obstacles such as orphans or those who grew up in foster care. I mean, it's similar to what you're seeing discussed even in the college admissions space, where how are kids basically trying to identify themselves that they are a person of color or that they are a diverse candidate without basically being explicit about it. So more to come and more to be seen in terms of how this is done. But I will say this, changing the language may not be enough to avoid scrutiny or litigation. And so maybe when we're here next year, we can give an update as to where we find ourselves in this ongoing challenge. But there's going to be a tension ongoing between efforts to promote diversity and efforts to have workplaces and other spaces in America that are colorblind or color neutral. So I talked the last time about a program I'm involved in with Chevron. They've got a diversity equity review committee, where basically their employees, it's free, open to everyone, where they can use that portal to basically say, I don't think I've been treated equitably, and it's something that's alongside their normal HR practices. So I'm a part of that with another neutral named Phyllis Chang, whom some of you may know. She's over at JAMS. I'll give them a plug. But it's a very interesting and unique program. But this is something that's near and dear to me as a former DEI executive at DirecTV. So it remains to be seen how this will all sort itself out, but more to come.
Warren?
And so I think that gets us to 9:09. So Bill, I don't see you on the screen, but if you're still around, I don't know. I guess I can open up the chat and see if there's anything that someone wants us to cover. I can't.
Thank you, guys. It's absolutely amazing. I mean, right on time, right on schedule. We do have a couple of questions that perhaps we can follow up on. I think I think this is probably a quick one. Rounding. Anytime rounding comes up, we're going to always have at least a few. that this will really hit close to home. So thumbs up, thumbs down, rounding. If you, in general, if you have options to rounding, what would you advise employers at this point?
Yeah, I think Patricia asked the question: is it better or safer for employer to have employees clock in exact time and not round, even if rounding is presently used? Bob, I'm sure you got a quick answer to that. I think you did answer it.
Well, yeah, the employer policy should be clocking in at the time they're beginning work, and you should not round. And then if workers are clocking in too early or too late, manage that through discipline of not complying with the company policy, but do not dock their pay in doing so.
I think the only rounding we should now talk about are the old Beach Boys song, "Round, round, get around, I get around." That's about it.
Warren,
Actually, actually, it's a great segue to what we're moving into as well. I'm going back to some of the oldies but goodies here, right?
do we have time? Can I ask a quick question of Warren?
Yes, sir.
On the diversity issue, Johnson and Weber, I didn't thoroughly read the Harvard admissions case. I still have yet to do that. But did the court discuss and expressly state that they were not making any kinds of opinions or thoughts about employment and under the Johnson and Weber cases?
No, the Johnson and Weber were not discussed. In fact, Grutter was not explicitly overruled. Clarence Thomas, in his concurring opinion, said that it effectively was overruled, but even the affirmative action case wasn't explicitly overruled. And so I will say this: it seems to me that there's always been the case, even for the admissions cases, have the universities been able to make the case that there's a demonstrated value. In other words, the argument by the court was, you've never really been able to demonstrate that diversity in and of itself is a value in higher education. But in the employment space, it seems to me, or even in that aid case I talked about, you ought to be able to make the case that you can show a value in terms of if African-American women have more problems with pregnancy and you give them aid to sort of try to avoid that, and ultimately those numbers go down, you can make that case. Presumably, if employers can make the case for the value of diversity, then I think going forward, you're okay. But making that, I mean, that's going to probably involve experts and statisticians and some costs. But no, there was no explicit references to those. So it's narrowly written in that sense.
Thank you.
Excellent, guys. Well, I want to thank you so much. I mean, I think we really covered a lot, and I appreciate everybody speaking quickly and going through this. It's so difficult to take these kinds of topics that are so weighty and so critical and synthesize them into just an hour. But you guys did an amazing job of that. I think we will have a couple of follow-up questions that we'll pose to you, and then we'll get that information out to everybody. But I really want to thank the three of you for being here today. And our regrets that we don't have Julie with us today, or Mark. I know they both really wanted to be here, but other situations prevented them from doing so. So really appreciate the three of you taking this, and Warren for taking the most difficult task of trying to keep everything on schedule. So
thank you. Our pleasure, Bill. This is a great group.
Thank you.
Thanks, guys.
Right.
Now gonna turn it over.
Good job, guys. Great job.
Likewise.
And turn it over in just a moment to Ryan Hawes for his employment law update. I just wanted to take 1 second to make sure everybody is familiar with how to find more Ryan's content. There's two different parts of Ryan's content, and you'll find them in the Word document that we provided to you. The one that's titled "It's the Most Wonderful Time of the Year." This is the slides. So this is what Ryan will be sharing with us on the screen. The one below that, the